Good afternoon, everyone. Why don't we go ahead and get started? Thank you so much for joining us today as we discuss restarting the economy, a practical toolkit for your business in the new normal. And thank you so much to the Association of Corporate Counsel for collaborating with us. My name is Katie Baker, and I'm a partner in the Nelson Mullins Boston office. I'll be updating you on the status of the reopening of the economy in Massachusetts, and I'll touch briefly on the process in some surrounding states. Then I'll go ahead and discuss best practices for developing your own written reopening plan, which is something that's now mandatory in Massachusetts. My colleagues at Nelson Mullins will take it from there. Rob Sheridan, a partner in our employment group, will discuss the strategies for mitigating litigation in the employment context and other risks associated with reopening, as well as COVID-19 and consumer debt. And Jim Bartling, a partner in our corporate finance group, will then present on opportunities and challenges in borrowing and deal making in a COVID-19 world. Kathleen Turland, General Counsel at Liberty Construction Services, will be adding color from the in-house perspective throughout the presentation. And for those of you who would like to submit questions for the panelists, there's a feature set up for you to do so on the side panel. We don't expect to have a live Q&A today due to time constraints, but we're going to respond to each question directly following the webinar. So let's turn to our first topic. On April 28th, Massachusetts Governor Baker announced the formation of the Reopening Advisory Board. The goal of this task force was to advise the administration on strategies to reopen the economy in phases based on health and safety metrics, meet with case stakeholders, and issue a report by May 18th. The 17-member board, led by the Lieutenant Governor and Housing and Economic Development Secretary, included representatives from the business community, public health officials, and municipal leaders. From April 28th to May 18th, the board heard testimony, accepted public comments, and met remotely with stakeholders. Governor Baker released the much anticipated 29-page reopening advisory report on Monday. He titled it Reopening Massachusetts, and it was accompanied by a new executive order and supplemental guidance materials. So the approach is a 4-phase gradual reopening driven by data trends. It weighs the public health risk of reopening against the economic benefit of doing so. Now, the state's progress between these phases that you see here will be assessed by 6 data points, which are the positive test rate for COVID, the number of deaths, the hospitalization rate, healthcare system readiness, testing capacity, and contact tracing. A so-called COVID-19 command center is going to provide updates every Monday on these 6 indicators. And each of the phases will last at least 3 weeks, with the potential for a backslide into a prior phase if the cases escalate again. Now, the first part of phase 1 began this past Monday. The report also lays out mandatory safety standards that all workplaces are going to need to follow to reopen. On the social distancing front, everyone's going to be required to stay 6 feet apart, both inside and outside the workplace. Employers are going to need to display signage to ensure that employees are social distancing and require masks for all employees as well. Employers have to provide hand washing stations throughout the workplace, stocked with adequate supplies, and they need to regularly sanitize high-touch areas. Employers are also going to need to provide training on social distancing and hygiene protocols and have a plan for sick employees in their return to work. They're going to need to also prohibit employees with COVID-like symptoms from reporting to work. Employers also need to implement business-specific cleaning protocols and make sure that they're going to clean and disinfect after each active employee is diagnosed with the virus, and otherwise just generally disinfect common surfaces at appropriate intervals. Businesses are also going to need to follow sector-specific safety protocols. Now, these are available on the mass.gov website for certain phase 1 sectors, including for office spaces generally. but other sector guides are going to be released in advance of future phases after consultation between state officials and those industries. The report also provides some general social guidance applicable to the general public and references the Department of Public Health Safer at Home Advisory. So these are pretty self-explanatory, but everyone's being asked to wash their hands, socially distance, be vigilant for symptoms, and stay home if you feel sick. Masks are going to be required for the general public when they can't maintain 6 feet of social distance. So in order to reopen, all businesses are going to need to do 3 different things. The first is be in full compliance with all workplace safety and sector-specific rules. The second thing is to complete self-certification. They're going to need to develop written COVID-19 control plans, which are kept on site in the event of an inspection, but you don't need to submit these in advance. Now, the state has posted a form on its website, which contains a checklist of required tasks related to workplace safety rules. This would count for the applicable self-certification plan. It would be a good idea to attach this basic checklist to your comprehensive internal reopening plan so that you ensure you have a written document that reflects you're following all mandatory rules associated with your particular business. Note that all individual businesses need to complete their own control plan, even if that business is part of a larger entity. The third thing you need to do to reopen is to post signs. The first type of sign is you're going to attest that you've complied with self-certification. This one must be visible to both employees and visitors. And then you'll have a sign for employees describing the rules for distancing, hygiene, and cleaning. There are also samples of these signs on mass.gov's reopening website. Now, for essential businesses which are already operating, they have until May 25th to comply with these standards, but that date may be a bit later for some of the sector-specific rules. On the enforcement end, the governor's office expects to see enforcement primarily triggered by worker and customer whistleblower complaints about potential violations. You'll see penalties range from verbal warnings to fines of $300 per violation, and then leading up to enforcement by injunction in court. So now I'll walk you through the specific phases of the reopening plan. The first phase is called START, and you'll see that some of these elements are carried over from the prior stay-at-home order. On May 18th, certain sectors were allowed to reopen with restrictions, and that included manufacturing and construction businesses. Hospitals were allowed to provide high-priority preventative care, pediatric care, and high-risk treatment. Childcare was slightly expanded to children of workers with no safe alternative. But on May 25th, there will be additional reopenings, and those will include laboratories, office space outside of the city of Boston at 25% capacity, hair salons, pet grooming, car washes, retail for curbside pickup, beaches, parks, some athletic fields and courts, and many outdoor activities. On June 1st, Boston offices will be allowed to open and also limited to 25% capacity. Phase 2 is called cautious. In phase 2, we might see the limitation on gatherings increased, but travel will still be discouraged. We'll also see retail, restaurants, lodging, and additional personal services open with restrictions and some capacity limitations. We'll see expanded in-person routine care, so you can go and get your dental cleaning. And we may see the phased reopening of childcare day camps. We'll also see an expansion of recreation and outdoor activities with guidelines. The earliest phase 2 could begin is June 8th. Now, the state hasn't provided much in the way of details on the restrictions for restaurants, which prompted some criticism recently, although the report does promise that those protocols will be provided before phase 2 begins. So phase 3, which is called vigilant, under this phase, the state left gatherings and travel to be determined. But on the business end, it looks like bars, casinos, gyms, and museums will be allowed to open, and youth sports will be able to hold games and tournaments with limited crowd size. The earliest we could see this phase begin is June 29th. Now, the state is the least certain about the details of phase 4 since it's the furthest out in time. In phase 4, the new normal, the state assumes that we're going to be able to resume public interactions with physical distancing and also resume travel with some social guidance in place. But all businesses and outdoor recreation would be allowed to fully resume operation at this point. At the earliest, phase 4 could start on July 20th. But keep in mind that we could be backsliding into earlier phases. Public transit service is going to be limited until phase 3, and employers are being encouraged to stagger schedules for employees and have a work from home policy in order to minimize traffic. On the side of protective supplies, the state has provided a guide for business owners on what types of supplies they can stock in the workplace, and also with respect to masks, hand washing, and cleaning. Helpfully, there is a portal that's been set up to connect businesses to manufacturers and distributors for appropriate supplies, since the scarcity of things like hand sanitizer and wipes has been an ongoing concern. So the guidance for schools is pretty light on details. What is certain is that K through 12 schools will remain closed through the end of 2019 to 2020 school year, with the remote learning still in place. Institutions of higher education will be allowed to repopulate their research labs and clinics and restart functions to prepare to reopen with social distancing in phase 1. Note that this report is not the end of the process, but only the beginning. These standards are inevitably going to change and become more detailed as new information comes in and the levels of COVID cases fluctuate. But now more than ever, it's crucial for businesses to form or shore up relationships with state and federal policymakers to help ward off legislation or changes to the reopening guidance that could negatively impact your business. The Nelson Mullins Government Relations team has been hard at work on that front. So surrounding states are taking similar steps towards reopening at varying paces. The governors of Connecticut, Delaware, Massachusetts, New Jersey, New York, Pennsylvania, and Rhode Island formed the Regional Advisory Council earlier this spring to coordinate reopening strategies. And this council has been hard at work looking at data and research, coordinating with health experts and economic development experts in order to develop a regional plan to gradually lift state stay-at-home advisories. Now, no formal plan has been issued from this council to date, but the coalition seems to be serving the purpose of at least shoring up public trust and buy-in for the extreme measures that state governments are imposing due to the virus. Governor Baker has told reporters that he believes that each state is operating on its own timeline based on its particular experience with the virus. Now, this makes sense when you think about the number of cases and deaths in the Commonwealth compared to surrounding states. Massachusetts to date has had about 89,000 total reported COVID-19 cases and 6,000 fatalities. On the other hand, Rhode Island has had about 13,000 confirmed cases and 500 related deaths. On the other extreme, New York has had 354,000 confirmed cases and 23,000 deaths attributable to the virus. This is a snapshot of New York's reopening plan, which began on May 15th. As you can see, it has been done in a region-based approach, primarily because New York City, the city that has been hit hardest by the pandemic, would not be able to meet the governor's baseline requirements for safe reopening as quickly as other regions. So far, several regions outside of the city have met all 7 metrics to reopen and began their phase 1 on May 15th. The New York phase 1 looks very similar to Massachusetts. In Rhode Island, the first phase of reopening began on May 9th. In that phase, retail, restaurants, healthcare, manufacturing, and construction businesses were allowed to open subject to new workplace guidelines. Restaurants there are allowed to offer outdoor dining with distancing maintained. And in New Hampshire, staggered reopening began on May 4th. Retail stores opened at 50% capacity, and this past Monday, restaurants were allowed to begin offering outdoor dining with distancing, but the beaches in New Hampshire remain closed. So moving to our next topic, now that the governor has made written reopening plans a prerequisite to operating in Massachusetts, you should be sure to develop one if you haven't already. Our employment group here at Nelson Mullins has come up with a safe office and wellness plan that I want to introduce to you today. It addresses several important topics, including those listed on your screen. So when you think about how you want to operate in the new normal, one of the first things you want to do is to get your employees on board. You want to tell them that you have a plan in place for their return to work, which should help them make them feel more comfortable. You want to give them a heads up that the workplace may look different when they return, and that you might be taking their temperature and asking them questions to determine any exposure to COVID-19. You should tell them too that there's going to be a protocol for reporting any illness they may experience before or during the workday. You're going to have to make decisions regarding visitors and the general public coming into your business, including about who wears masks and whether you need to limit capacity by regulating entrance to your facility. You should also consider limiting third-party vendor access unless they're going to agree to follow your protocols. So you should try to identify and isolate people at your work site who may have the virus. To that end, you are allowed to take temperatures, ask questions about symptoms and who employees have come into contact with. But for this purpose, you should have a designated, trained management employee to do this. The screening itself should be conducted in an isolated area, separate from the view of the general workplace. And you could use a wellness room or a nursing mother's room for this. And that room should be stocked with sanitation supplies and testing equipment. You should keep a log of your testing information in order to comply with any reporting requirements for your jurisdiction and industry. But in doing so, you want to make sure you're complying with confidentiality, privacy, and HIPAA laws. So any testing and medical data that you do collect from employees must be kept in a separate file from their regular HR employee file. Now, if someone does register a high temperature or respond that they came into contact with someone who tested positive for the virus, you can send them home from work. And that space that you're using for testing could also be used if an employee is not feeling well during the workday. You should have a protocol in place to assist the sick employee while at the workplace and in getting home or to receive appropriate medical attention. You should consider using a communications protocol for employees who are continuing to work after a coworker is diagnosed with COVID-19. Now, that communication can reveal that a person was diagnosed and left work, the date that that employee stopped working in the office, and that you're assuming the employee is home self-treating. So sanitation protocols are, of course, a crucial part of your effort to combat the virus in your workspace. Your plan here should make sure that all employees practice good hygiene in their own office space and in the common areas, and that they're also practicing social distancing. Signs are going to come in handy here as a good reminder. The CDC, OSHA, and state government standards provide very helpful information on sanitation. The CDC has a link to approved EPA cleaning and sanitizing devices and products. And as I mentioned previously, Massachusetts has set up a portal to help get you the supplies that you need. All staff need to be trained in sanitation and hygiene protocols, including about consistently washing their hands, keeping workspaces clean, and not sharing devices or materials. You want to make sure that people are not touching the same surface without proper cleaning in between. And you should probably do a deep clean before you reopen, and again after any employee tests positive for the virus. So when we're targeting a virus-avoidant workspace, you need to look at your space and think, how can I keep my employees as separate as possible? Of course, this becomes more difficult in an open floor plan setup, but it's something that can be accomplished. You should consider staggered schedules or days if possible. For example, if you could have Team A come and work on Monday and Tuesday, Team B works Wednesday through Friday, or have people come in at different times, that's going to reduce the amount of people using the common areas simultaneously. You should also think about continued telecommuting and remote work, depending on your particular business. In Massachusetts, that is definitely something that's being encouraged. Within your space, can you set up a single direction pathway that may make sure that people aren't coming into contact with others? Also consider improving your ventilation systems. So when we talk about personal protective equipment, it's goggles, gloves, and 95 respirators. An ordinary employer typically does not have access to this type of equipment unless they're in the healthcare industry, and the state is assisting those facilities in getting proper supplies. But Massachusetts and other jurisdictions require that other types of employers provide basic COVID supplies. Face coverings can be required by an employer and are required for all employees in Massachusetts. But the cloth-based mask is not technically PPE. It's there to minimize exposure to droplets of the virus in speaking or coughing. We do recommend providing masks to employees which comply with relevant guidelines for your jurisdiction. For other types of PPE, you'll have to look to guidance for your specific industry and your level of contact with infected individuals. So training is going to be critical here for a number of reasons. First, training on COVID policies is mandated by Massachusetts and other jurisdictions, and it's going to also help establish a greater comfort level for your employees to return to the workplace, which is very important during this pandemic. Before an employee returns to the workplace, we recommend informing them about your plan. Provide your written blueprint for reopening to them in advance, and then conduct a call or a webinar like this one to explain how that plan is going to work. What should they expect on day one? What will you do before employees are able to access the work site? Will they be tested? Will you take their temperature? Are you going to require them to wear a mask or other PPE? Will you allow them to provide their own mask? Decide in advance too whether you're going to have a different schedule. Will you alternate work days or the start and end time of their shift? And even if an employer does training to restart their workspace, it is prudent to conduct follow-up training or reorientation from time to time. So Kathleen, what types of steps have you taken with respect to COVID training at Liberty?
Thanks, Katie. We have a team focused on returning to the office and one focused on returning to our construction job sites. For our office employees, we've taken a lot of your good advice here, and we've produced a video in-house which shows employees what it will be like when they return to the office from the moment they arrive to when they leave at night. It provides employees with a visual on how their temperatures will be taken, how employees will interact in the office, and what it looks like as employees interact in common areas wearing face masks. We've instituted a clean desk policy, so each day before people leave, they put away everything that would sit on their desk so the cleaning crew can clean more thoroughly. We've added new signage around the building, reminding people to wash their hands and listing how many people can use each conference room while maintaining social distance. We've also mapped out desk locations to ensure 6 feet between desks and are determining in Boston who will return in the initial wave given the occupancy limits you spoke about. On project sites, we've supplied gaiters and masks, and we have supplied PPE, which may be relevant to a person's particular job, such as a face shield for our hoist operators. The general contractors we work with are taking temperatures on site, and we have a hand washing station installed wherever we can and have provided hand sanitizers to all the job sites. We've also provided extra cleaning supplies and cleaning crews who wash down handrails and common spaces. We also have protocols in place for a deeper cleaning if that's needed.
That sounds great. Thank you for sharing, Kathleen. So if an employee does go out sick, an employer is going to need to know what leave benefits are available. These benefits should be detailed in your reopening plan. First, you're going to want to review your existing PTO policy from your employee handbook. There are several leave laws that need to be reviewed and considered with respect to COVID, and I'll just highlight a few. In the Nelson Mullins reopening plan, we include a Families Fair Coronavirus Response Act policy and a leave request form to make it user-friendly. So if you have less than 500 employees and you're not a small business under 50 claiming a hardship and therefore exempt from the FFCRA, then you are required to comply with that act. An employee who is experiencing symptoms of COVID-19 and is seeking a medical diagnosis is entitled to paid sick leave under the Emergency Paid Sick Leave Law, which is part of that act. You're entitled to have an employee who's taking this type of leave for COVID provide documentation to you with the reason for the leave. If you're not covered by the FFCRA, your employees may be eligible for FMLA leave, for which COVID-19 would qualify as a serious health condition. And they may be able to use state paid sick leave benefits as well. Keep in mind that state laws may vary on this topic, and you're going to want to be sure to understand those that apply to your business. Also note that if an employee contracted COVID-19 at work, he or she is covered by workers' compensation. So make sure to check state executive orders regarding COVID-19 and workers' comp. Finally, employers must keep in mind their policies against discrimination in the workplace, both as to employees who test positive for COVID-19 and those who claim to be symptomatic. An employer cannot retaliate against anyone who is sick with the virus. So Kathleen, feel free to add your commentary on this topic as well.
Sure. Thanks, Katie. In my experience, I think having protocols and decision-making chains in place is critical. Employees and management need to know who will be making the decisions for employees if they become sick. They need to care for someone who is sick or they're unable to return to work for another reason. The time to make a decision is short, and as you mentioned, the number of laws which may be applicable is broad. Determining which law may apply to your situation can be a complex decision tree when someone needs to take leave and you may need to consult external counsel. This is especially true when you're dealing with a job site in a different state where there may be a specific state or county or even a city law that might apply to someone. One thing we did internally was set up a simple one-page FAQ document for employees which outlined who to call and generally what leave was available, with a caveat that additional laws may also apply. We also had a plan for how to make decisions. So if an employee becomes ill with a suspected case of COVID-19, our employee or their manager knows to contact either our National Safety Director, our HR team, or me. Whoever is contacted gathers the relevant facts, assembles the others virtually, and we develop a plan to respond to the employee together. Safety would generally handle any on-site response in terms of cleaning protocols and preparing incident reports if the employee works on a project site. I look into the laws that apply, and then we work with HR to make sure we get the right leave policies in place. One other thing is I would also recommend that you think about who helps your business with short-term and long-term disability claims and have those numbers available in case someone needs an extended leave.
Thanks so much, Kathleen. With any reopening plan, you'll want to be sure that you're following the mandates of the particular jurisdiction in which you're operating. You'll need to monitor any change in state or federal guidelines as this year progresses. And now I'll turn it over to my colleague, Rob Sheridan. Rob?
Thank you, Katie. As Katie mentioned, my name is Rob Sheridan, and I'm a partner in Nelson Mullins Employment Group. If we could go to the next slide, please. So I'm going to first cover the fact that your reopening should have an eye towards litigation avoidance, and following the best practices that Katie mentioned is a great start for that. Thinking carefully now about these issues is going to be a hedge against future litigation. At present, approximately 1,000 cases have already been filed across the country related to COVID-19, and we expect this number is going to grow as courts reopen for normal business. I'm first going to cover the following areas of employment-related litigation avoidance tips: discrimination, OSHA, wage and hour, and terminations. Next slide, please. Okay, so in your reopening, you want to avoid discriminatory practices. And the first statute we're going to talk about is the Americans with Disability Act, the ADA. Remember your protected classes here and ensure that your return to work protocols are not discriminatory in practice or effect. For example, we know that COVID-19 disproportionately affects older individuals. This does not mean you can allow your younger workers to return to work, but leave all of your older workers. And remember that older under federal law is 40 or up at home. However, if an employee requests to work from home as an accommodation because of some health condition that might be exacerbated by COVID-19 concerns, this would be okay. Work from home is a recognized reasonable accommodation, so it's assigned to engage in the interactive dialogue and see if it might work for your organization. The other thing to remember here is to guard against retaliation. Employers have to remember their policies against discrimination in the workplace, both as to employees who test positive for COVID-19 or those who claim to be symptomatic. An employer cannot retaliate against anyone who is sick with the virus. As a pretty obvious example, it would be unlawful to fire an employee simply because that person has COVID-19. Let's talk a little bit about medical testing. As Katie discussed, you should advise your workforce in advance what new protocols are in place, including testing and screening. Many return to work protocols will entail some sort of screening to ensure that employees are safe. So what kind of questions can you ask about an employee's health? How about, do you have a fever, chills, cough, shortness of breath, or a sore throat? Have you recently lost the ability to smell or taste? Well, yes. These are permissible questions. These are actually the CDC's recognized COVID-19 symptoms. How about, do you need a reasonable accommodation? As we previously discussed, yes, this is a permissible question. How about this one? Do you have an underlying condition that puts you at a greater risk of complications if you become infected with COVID-19? No, this would likely violate the ADA and another federal law known as the Genetic Information Non-Disclosure Act, or GINA. How about temperature checks? Well, temperature checks in normal times are considered medical examinations under the ADA, which are restricted. But because the EEOC has designated the COVID-19 pandemic as a direct threat, temperature checks are permissible. However, if you decide to have your own employees take the temperatures, as opposed to outsourcing, make sure, as Katie mentioned, that these employees have the right training, the right setting, and the right PPE to ensure that they are safe. And then just to emphasize a point that Katie made, any medical information obtained from screening should be maintained separately from employees' personnel files. The ADA and other state laws require that you keep this information confidential. Next slide, please. All right, how about OSHA? Well, under OSHA, you have a general duty to protect all employees and ensure that you have a safe workplace. With respect to COVID-19, the OSHA horizon has changed. So for instance, if you have employees who are doing the deep clean with hazardous cleaning materials, make sure that they have appropriate training for this cleaning. In addition, if you're an employer that is required to keep OSHA injury and illness log, OSHA has issued guidance on May 19th, so just a couple days ago, which requires such employers to determine if workers' COVID-19 cases were job-related. Which employers are required to keep OSHA logs? Well, most employers, except those with 10 or fewer employees or in certain exempted low-hazard industries. Let's talk about some safeguards. For PPE, as Katie discussed, an employer should decide if they are providing PPE. We strongly encourage employers to provide PPE to employees. It's going to make them feel safe, and it's going to be create some consistency with respect to the PPE that's used in your workplace. Social distancing, we're all unfortunately very aware of this term, and this may require some creative reconfigurations of your workspace, including one-way hallways, bathroom configurations, and appropriate setups in your elevators. You should also make sure that you follow your state and local guidelines, which are likely to be changing frequently. Katie spoke about Massachusetts and some of the surrounding states, but it's important to keep up to speed on these, as they will not only keep your employees safe, but it's also going to protect against future lawsuits. In addition, you do have an obligation to notify your employees of safety risk. You also have an obligation to mitigate that risk if you know of it. For example, if you become aware of an employee who exhibits symptoms consistent with COVID-19, you should take steps to care for that employee, such as putting the employee in an isolation room, make sure that employee gets medical attention, and then implement in as confidential a manner as possible contact tracing to notify those other employees who may have come in contact with the afflicted individual. Having a plan beforehand and implementing that plan will be critical and will also mitigate the risk of an outbreak at your work site. As I mentioned at the outset, we are already seeing an onslaught of COVID-19 lawsuits, such as the Walmart case referenced in the slide, which contains negligence and wrongful death allegations related to a worker who died of COVID-19 complications. Kathleen, what are you doing to allow workers to notify your company about risk?
You know, one thing, Rob, which is a great idea, a great way to have people notify us about risk or potential risk they see, is an ombuds process. We have an ombuds system in place in the company, and if other companies don't have this yet, it's something you may want to consider doing. It's a great way for employees to communicate concerns confidentially or anonymously. It's also a great way for an employer to track and respond to employee concerns, mitigate risk, and it can act like an early warning system of potential issues that may be brewing in your business.
That's great. Thank you, Kathleen. The next area, which Katie mentioned briefly, is workers' compensation. Workers' compensation is generally the exclusive vehicle for relief for workplace injuries. If a worker contracted COVID-19 at work, it is covered by workers' compensation. Keep in mind that the state executive orders regarding COVID-19 are changing rapidly. For example, the California executive order provides a rebuttable presumption that an employee's COVID-19 related illness is connected to employment for workers' compensation purposes if the employee tests positive or is diagnosed within 14 days after a day that the employee performed labor or services at the employee's place of employment. This presumption does not apply if the employee worked from home. General liability, some plaintiffs' lawyers are already going beyond workers' compensation and claiming intentional misrepresentation and negligence. The best thing that you can do here is to have a written plan, stick to the plan, and train your workers. Next slide, please. All right, because the return to work process may be gradual or phased in, I'm going to give you a few reminders about the wage and hour implications of the new normal. So how about a reduction in hours? All right, you have to think about the exemptions here. For exempt or salaried employees, if they work anytime during a work week, they are generally entitled to their full salary. For non-exempt hourly employees, they are only entitled to pay for the hours they worked. So if they're doing no work and otherwise not entitled to paid leave, then the baseline is they are not entitled to pay. A reduction of hours has a variety of implications that a company has to stay attuned to, including the potential that employees could lose exemption status by falling under salary threshold. You also have to think about benefits. All else being equal, employees could lose benefits eligibility if hours are reduced beyond the threshold required by the applicable plans. We have found throughout this crisis that insurance companies have been very accommodating in fashioning solutions to help companies deal with the crisis. How about working from home for non-exempt employees? For non-exempts, make sure you have a system in place to accurately track time and be clear about working expectations. What about the pre-employment screenings that we talked about? Well, for non-exempt or hourly employees, they are entitled to pay for time worked, and that includes time that is more than 5 minutes a day spent preparing for the workday or completing the workday. If a non-exempt employee spends time to wait for his or her temperature to be taken before the start of a shift, that time is compensable if it is more than 5 minutes. Next slide, please. All right, so I think we're all hopeful that this economy will rebound, but given the uncertainties, furloughs and layoffs are likely to continue. How about a furlough? Well, a furlough is a mandatory suspension from work, and it's generally without pay. It can be as brief or as long as the employer wants. And what's the difference between a furlough and a layoff? Well, a furloughed employee generally has an expectation of return to work. Generally speaking, a furloughed employee also retains their benefits. The key with respect to compensation here is that no work can be done by the employee during the furlough. Once an employee does work during the furlough, a payment obligation is triggered. For non-exempt, this is not as difficult from an administrative point of view, as employers do not have to pay non-exempts for time not worked. But for exempts, any time during a work week, i.e. answering a single email, would entitle the exempts for their full salary during a work week. You can structure furloughs to maximize unemployment benefits for employees. One of the things we recommend is that access to facilities generally be restricted as to furloughed employees, but the call should be made based on the business needs of the company. In addition, consider restricting email and company media access for furloughed employees for the duration of the furlough. All right, how about layoffs and plant closings? Well, I'll first talk about the WARN Act. The WARN Act is a federal law that applies to employers with 100 or more employees and requires 60 days notice of termination to affected employees in the event of a mass layoff. What is a mass layoff? It's a reduction in force within a 90-day period that results in employment loss at a single site of employment of either 1/3 or more of the site's employees and at least 50 employees, or 500 or more employees, or a plant closing. The WARN Act has aggregation rules, so if you're planning a series of mass layoffs in quick succession, it is best to speak with your counsel now regarding compliance. In addition, many states have so-called mini warns, like California and New York, and they have lower threshold and different notice periods and other features. So again, companies have to consider all the applicable rules in tandem. I want to note here that the WARN Act and the state cognate have an unforeseen business circumstances exception, which most practitioners think will be applicable to COVID-19 disruption. How about a non-WARN reduction in force? Remember, you still need to follow appropriate protocols, including review and revocation periods under ADEA and the OWBPA for those affected workers who are over 40. With respect to unemployment, as you probably know, many states have changed their rules regarding unemployment eligibility and eliminating waiting periods. The benefits determination is ultimately up to the appropriate state's Department of Unemployment, but if employees are laid off, they are generally entitled to employment benefits. Two more things on this. The CARES Act, with layoffs, reductions in force, and reductions in hours and furloughs, you have to take in consideration the implications for loan forgiveness under the CARES Act, particularly if you got a PPP loan. Finally, good reason. If you have employees with employment contracts, check the good reason language in their agreements to determine if a severance obligation might be triggered by the adverse employment action. Next slide, please. So now I'm going to do a very brief discussion on some of the changes implemented by COVID-19 with respect to consumer debt. Next slide, please. In a welcome development for many young attorneys and recent graduates, under the CARES Act, payments for federally held student loans have been suspended through September 30th, 2020. In addition, these suspended payments will be reported to the credit bureaus as if they were on-time payments. Interest on these loans will not accrue during this period. In addition, the CARES Act suspended involuntary collections of federally held student debt through September 30th. Next slide, please. Unfortunately, the CARES Act changes only apply to federally held student debt. That leaves many borrowers indebted via private student loans out of luck. However, a number of states have entered into agreements with private student loan servicers to provide COVID-19 relief. This relief includes payment forbearance for 90 days, waiving late payment fees, agreeing to not report derogatory information like late payments to consumer reporting agencies, and ceasing debt collection lawsuits for 90 days. Next slide, please. In addition, the CARES Act also amended the Fair Credit Reporting Act, the FCRA, creating new reporting requirements for those institutions that provide credit information to credit reporting agencies. Namely, if an institution here, like a credit card company, makes an accommodation to a consumer because of COVID-19, and that consumer then makes the required payments or is not required to make payments pursuant to the accommodation, then the institution must report such obligation or account as current or in the same status reported prior to the accommodation. The CARES Act defines an accommodation as an agreement to defer one or more payments, make partial payments, forbear any delinquent amounts, modify a loan or contract, or any other assistance or relief granted to the consumer who is affected by the COVID-19 pandemic. Next slide, please. So on March 26, 2020, in response to COVID-19, the Massachusetts Attorney General's Office issued wide-ranging emergency regulations relating to debt collection. In short, these regulations prohibited initiating debt collection calls and filing or threatening to file debt collection lawsuits or exercising other legal and equitable remedies to collect debt. However, these regulations went a step further than just prohibiting these activities. They made these activities unfair and deceptive practices, conferring a right of private action under Massachusetts Consumer Protection Statute, Chapter 93A. Next slide, please. So the trade associations responded. A trade association for collections agencies filed for an injunction against these regulations on May 6th, Judge Stearns in DMAS enjoined the AGO's enforcement of these regulations as an unconstitutional restraint on commercial free speech. We provided a citation if you want to review the opinion. Judge Stearns found that the regulations violated the constitutional rights of creditors and debt collectors in Massachusetts to engage in free commercial speech without providing any meaningful protections for consumers beyond those already afforded by existing consumer protection laws. Accordingly, Judge Stearns' order invalidated the majority of these regulations. I will now turn it to my colleague, Jim Bartling.
Thank you, Rob. Good afternoon, everyone. As Katie mentioned at the outset, my name is Jim Bartling, and I'm a partner in the corporate finance group of Nelson Mullins. And I would like to spend a few minutes with you today discussing the opportunity and challenges as we prepare to move forward in the COVID-19 world with respect to borrowing and deal making. Next slide, please. Next slide, please. Thank you. Thank you. So before COVID-19, the banking and the mergers and acquisition industries in general had experienced a prolonged period of growth and prosperity dating back to the 2018 recession. COVID-19 came as an unprecedented market shock, resulting in a drastic, near universal reduction in transaction volume. With discretionary spending at a near complete halt and a disruption of core work processes and levels that were unseen before, COVID-19 has rippled across industries with a tidal wave of unforeseen consequences that continue to emerge. Next slide, please. It was a reaffirmation that Black Swan events do indeed occur, and we should always, as best we can, prepare for them, their inevitability. As a result of the crisis, the market for leveraged debt financing came to a near close in most private equity firms and went pencils down on all of their current investments. For those transactions that were able to move forward, a few, although the federal interest rates remain low, margins on debt financing have increased across the board. Next slide, please. So in response to the crisis, we've seen a number of companies implement several countermeasures to try to combat the issues that were presented. For example, borrowers were rushed immediately to build liquidity war chests through things like drawing down on debt facilities, looking for extensions on payment terms for debt service from their loan providers, asking for rent abatements from landlords, extensions on trade payable terms, and other expense reduction measures such as reductions in workforces and general expense belt tightening. As many of you personally experienced, there was a forced acceptance across industries and an implementation of remote employment platforms. For some borrowers, they were fortunate to obtain some immediate economic relief under the CARES Act through financing such as the Payment Protection Program loans or the Economic Industry Disaster loans, and also there was some measure of payroll tax relief as well under the CARES Act. Next slide, please. As we plan for the future, with no precedent crisis having occurred in our lifetimes, this makes forecasting for a post-COVID-19 world very difficult. And it's not possible to completely assess the magnitude of the effects on either a macroeconomic or an industry level just yet. It is, however, not all bad news. The elements for a bullish rebound of M&A activity do exist in the marketplace. For example, levels of dry powder are at record highs, with private investors having amassed $1.5 trillion in cash at the close of 2019, according to Preqin. That money still needs to be deployed. We had, leading into the crisis, a robust and healthy economy, which should aid in the recovery as we prepare to move forward. There's likely to be a decrease in what were record high valuations on target companies, which should, in theory, lead to an increase in deal volume as we move forward. The low interest rate environment that we enjoy today is likely to continue for the foreseeable future. There's no indication from the Federal Reserve that there's going to be any imminent changes in that monetary policy. Access to financing, both from banks and private credit providers, remains plentiful. This is very different than what we saw in 2008, where there was a relative dearth of financing opportunities available. So, in addition to that traditional bank loans, there's also been a number of distressed and special situation funds that have been raised serendipitously over the past few years in anticipation of a more generalized downturn that are and should be available to deploy as a result of the COVID crisis. Finally, over the past few years, there's been a focus on digital innovation and technology disruption in most lenders and investors' underwriting practices that have prepared those deal makers well for the current crisis. Next slide, please. As we look forward, deal makers anticipate that COVID-19 will have a far-ranging impact on all future transactions. For example, material adverse change clauses or MAC clauses, which give buyers an ability to walk away from transactions before closing, are likely to be significantly reshaped to include specific references to either COVID-19, epidemics, and pandemics, depending on the leverage of the parties involved. And due to the wide-ranging impact we saw of shutdowns related to COVID-19 and possible shutdowns in the future, buyer and lender due diligence on target companies going forward will likely include a more detailed analysis of the geographic scope and the dependencies of a target's operation, a focus on supply chain reliance and resiliency, a review of force majeure provisions in key commercial contracts to assess the presence or the absence of COVID-19 triggers. And finally, a more thorough review is expected of employee access to healthcare services as a result of this crisis. Next slide, please. Finally, in addition, at least at the outset, as we move forward, the expectation is that transaction timelines will inevitably lengthen, given the need for increased diligence and potentially longer lead time from government agencies on required consent. And lastly, valuations on target businesses may be more difficult, leading to challenges making things like non-cash considerations, such as structuring earn-out payments, stock consideration, and seller notes, given the impact of COVID-19. And now I'll turn it back to my colleague Katie for some closing remarks. Thank you very much for your time.
Great, thanks, Jim, and thank you to all my esteemed panelists for enlightening us on ways to operate your business successfully in the new normal. As a reminder, we will answer any questions that have been submitted through the platform directly following the webinar. Thank you all for joining us, and take care.